Good evening, everyone. Thanks again for joining the series of webinars we are having since last 3 months. Just to introduce about myself, I don't want to take much time. I'm Kishore from Houston, Texas. We had over 40 plus webinars in last 8 weeks. We have another webinar tomorrow on kids college admission process, how to get into elite colleges. And also I want to request everyone to follow groups like Immigration Voice. They are doing a great job for 380S 386. And also please make sure to call Senator Dick Durbin's office at 202-224-2152, right? Because today it is colleges, tomorrow they may say that H1s also don't need to be, they can go to India, they can work from India, right? Anything can happen. So if we are in comfort zone without doing anything for making things better, without fighting and without doing our part of it, right? We 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 generally don't take it serious. We leave it for others to do it for us. We think it is a birthright to get green cards or citizenships. So please take it serious that there are hundreds and thousands of people are fighting for it. Everybody support them, support the process so that even some minor changes also can help millions of people. Then let me also introduce our guest speakers today, Mr. Rahul, founding partner of Reddy and Newman PC, member of Immigration Lawyer Association since 1995, and practicing employment-based immigration since last 23 plus years. We've had like hundreds of sessions, various webinars. Rahul is always supportive to our group members. And also Rebecca, she also supported in maybe 20-30 webinars, which we conducted since last 2+ years, 3+ years. Rebecca is also part of Reddy and Newman PC. She got a great experience in the immigration field, especially with complex business immigration matters. Thanks again, Rahul and Rebecca, for taking time to talk about the latest immigration updates, what is happening with the college for F1 and M1 students, and also what is happening with the DACA, what is happening with this H1, H4 extensions, furlough of USCIS, how it will impact the overall H1 extensions or the travel process. Thanks again for taking time, and it's all yours, Rahul. You are still on mute, Rahul. Let me. Yeah.
Hey, thank you, Kishore, for inviting me and Rebecca in this meeting. First thing is that Rebecca and I am messengers in this one. Don't shoot us, please. We are not the people who did anything. We are in the middle of a war with the pandemic right now, and we don't know whether our administration is fighting the war with the corona or they're fighting for corona. We're unable to understand. And when we understand the administration, if they are fighting corona or they're supporting corona, we will let you know, because at this point of time, I'm unable to understand which side our administration is. Now, coming to the many policy changes that occurred in the past couple of months, you have noticed that there is a complete H-1B ban, H-4, L-1, L-2, and also J-1 ban for the people who are going to get the visa stamping. There is no visa stamping until January 1st of 2021. Based on the history of this administration, we don't even know if he may continue the executive order for the next 6 months after that at this point of time. Now, while we are in the pandemic right now, we're having the CDC, the Disease Control Division of the government branch, which is issuing notices saying that don't go to colleges, don't go to these things. And now we do have the Trump administration. You don't go to college, you have to leave the country. That's one. He's not only doing it for the student visa. I saw the news right now recently that he is even threatening that he's going to defund the Department of Education if they don't force their US children to go to school. If they don't force them, he wants to defund the Department of Education too. He's going to that extreme measures. Now, can you update on this ICE notification, Rebecca? What does it mean for the students? Now the universities are telling don't come because You may get sick, you may get the other people sick, get sick, you may get the faculty to get sick, and you may get the entire people to get sick. Don't just stay at your home and attend, is what most of the universities did at the end of the semester, in end of semester. And now we have a different direction from ICE. Can you explain which one we have to listen and what to follow, Rebecca?
Right. So in March, when schools across the country were shutting down, basically sending college students home from campus, at the time, ICE, which administers the Student Exchange Visitor Program, SCVP, they allowed some flexibility at the time in March and announced that students who are here on F1 visas would be given flexibility, because the default rule in a normal year without a pandemic is that F1 international students are limited in the number of percentage of online courses they can take in their course load for a semester. So it's usually limited to 3 credit hours or 1 class out of their course load per semester. That's the maximum for online courses in a normal year before COVID. Obviously, when everything just all of a sudden was shutting down in March, ICE did provide some flexibility at that time and allowed F1 students who are here in the US. I mean, no one could go anywhere anyway, international flights were canceled. And so they allowed international students to continue their studies online through whatever means the schools were providing it for the rest of this last semester and into the summer. It was widely expected that ICE would continue that for the fall semester, because as the news clearly shows, we are no safer really right now than we were in March. As far as COVID cases, the US has the highest number now out of any country. And so right now, at this time when universities are making the decisions about whether and how much and in what way to possibly reopen for the new school year, ICE has come out with this announcement where they have announced on Monday, basically pretty unexpectedly. Nobody really had any pre-knowledge or inkling that this was coming out, but ICE announced that they were not continuing the modifications that they started in March, and that going forward for the fall 2020 semester, for universities that would be continuing exclusively online courses, that basically international students who were either coming to the US, who are outside the US now, will not be able to get F1 visas or entry into the US to attend schools that are anticipating an online-only program. Students who are here in the US right now enrolled at those colleges already will not be permitted to stay. They could be potentially put in removal proceedings if the college that they're enrolled in now decides to continue in an online-only format for the fall semester. Basically, the SCVP guidelines gave kind of 3 different scenarios for the schools. So that first one is what I just described. If the school is online only, basically they cannot have international students. You can't maintain F1 status at an online only school according to these new rules starting this semester. The second scenario is if the school is planning to be completely in person, going back to normal, basically, as if the COVID situation is not there. If the college is reopening completely, then F1 international students enrolled at those schools are subject to the same rules that were in place before the pandemic, which is a maximum of 3 credit hours or 1 online class per semester. So that's the second scenario for schools that decide to reopen completely. As far as I know, it's most likely a very small percentage of schools that are going to be in that situation. And the third situation the SCVP outlined is a hybrid model, where the school will reopen in-person instruction to some extent and also continue online instruction. In that situation, in that hybrid model of in-person and online instruction, the SCVP guidelines that came out this week say that in that case, students will be allowed to take more than the normal 3 credit hours that are reserved for online. They can take more than 3 credit hours online, but they don't specify how much more, except that we know that it cannot be 100% according to these guidelines. So that's basically the structure that was outlined in this most recent announcement. It took international students by surprise. It took the universities by surprise. Colleges just, in the past couple of weeks have started announcing what they plan to do. And this is kind of potentially upended all of that. Harvard, for example, just announced on Monday morning that they intended to continue exclusively online classes for this next semester. If these SCVP guidelines are allowed to remain in effect, basically Harvard cannot have any international students for this semester. So that's the basic guideline. In addition, schools have until July 15th to certify to SCVP of
That's
what
1 week
kind
from
of
now.
model.
That's 1 week from now.
Yeah. 1 week from today, and basically 9 days since the announcement, to inform ICE basically which of those 3 models they are going to be: exclusively online, exclusively in person, or a hybrid. And then based on that, all international students will need to get a new I-20 certifying that their school is not exclusively online, to prove that they are able to continue valid F1 status.
So each student has to go and get their I-20 endorsed again right now.
Yes, so I imagine that would be only after July 15th. If the guidelines are allowed to go into effect, that would only be possible probably after July 15th, once the schools have certified to ICE what kind of model they will have. Those I-20s can be provided to students electronically. That's kind of the only flexibility that's still there. It used to be that you had to get the original I-20 with the DSO's original handwritten signature. They're allowing I-20s to be provided electronically to students for now, but that's basically the only possibility. Everyone still needs to get a new I-20 to at least certify that the school is not 100% online for the fall semester. So it is just kind of a mess right now. International students don't know what to do. DSOs, I'm sure, are panicking. School administrators are trying to figure out what to do. It is an extremely short amount of time for the universities to decide what to do. They're already in a very difficult financial situation because of decreased tuition and everything else going on. Many of them are, if these guidelines are allowed to go into effect, are going to be pressured to go into a hybrid model, at least, in order to protect their international students, protect their international students' status, whether or not that's in the best interests of their health or anyone else's health, of the staff, faculty, other students on campus. It is a very troubling decision or announcement.
As far as the furlough is concerned, at this point of time, August 13th is the date where the funds seems to have exhausted. So they are expected to furlough about 13,000 employees. That's a huge number. Mostly the reason is that this administration has changed the policy so many times. They have introduced the 944 application. They have done student visa. They have done a lot of different changes. They've introduced the biometrics. Because of all these things, the USCIS is now completely broke. And I think so this administration did it intentionally to break down USCIS so that they delay everything. If you guys have any extensions to be filed, I would want you to file it immediately. If you're eligible for the premium processing, I would want you to avail the premium processing, pay the extra money, and then get it done before August 13th, 2020, try to expedite as much as possible, file as much as possible. There is a good chance that the Congress will fund the USCIS to extend the deadline of August 13th, because they won't let the employees to go on a furlough, especially the government employees. However, we would like you guys to prepare as much as possible. If you have any applications that need to be filed for extensions, please file it right now. Don't delay it. Do it in the premium processing. We have also been informed that the DACA, which the EADs for the students who came in when they were under 15 years of age and they are now unlawfully present in this country, the Supreme Court has struck down the executive order issued by the Trump administration. But now the Trump seems to be coming back and modifying some of the requirements, try to comply with the Supreme Court and the other regulations that are there, and see if he can still ban the DACA. That is not yet official, but we're expecting that to come out too. Rebecca, can you update what's going on the biometric situation with the USCIS? Are they opening it? What about the interviews, adjustment of status interviews? What about the consulate? Are they open? They are not open right now.
Yeah, so almost everything has been closed since March due to the pandemic. It was announced previously that USCIS offices or ASCs would start reopening June 4th, but for the most part that has not happened. It seems like it has happened to some extent for some local USCIS field offices, but not for the application support centers yet, as far as we know. And those ASCs are where the biometrics are done. So if you haven't received your rescheduled biometrics or your new biometrics notice for an I-539 filed in the last three or 4 months, that's normal. Almost nobody has gotten, or nobody as far as I know, has gotten a rescheduled biometrics notice. The most recent announcement on when biometrics offices will be reopened is that they will start a phased reopening July 13th. So later this month, in about a week, is when ASCs, application support centers, are supposed to start a phased reopening to start taking fingerprints again for I-539 applicants. As far as I know, in our office, we have not gotten any rescheduled notices yet. As of yesterday, I think I checked with Emily and we still haven't seen any. We're not sure what phased reopening means, if that means only some offices in the country or all offices will be open, but to a percentage capacity, we are not quite sure yet. But it is likely going to be still several weeks, possibly months, for people to get their biometrics notices, because they have a lot of backlogged fingerprints to take from March, April, May, and June. Plus, there were a lot of I-539 applications filed during the pandemic for people who were stuck here and whose only option was to file B2. So they all have to be fingerprinted. On top of that, biometrics offices are, and all USCIS offices are going to have new guidelines in place to limit capacity and volume, of course, for safety reasons. And so that's going to limit the number of appointments that can be seen each day. So biometrics are supposed to restart this month, but don't be surprised if it's still several weeks until you get your biometrics notice. USCIS offices for naturalization and I-485 interviews those happen at the field offices in each city. It sounds like those are already starting to reopen since last month on a city-by-city basis, kind of just depending on the health situation in that local area. So those will also start to, I have seen some naturalization interview notices resent for some of our clients in the Northeast. So it looks like those are just happening based on each field office's discretion of whether it's safe to reopen. So you can start seeing those. In any case, when you get those notices, rescheduling your interview or an interview for the first time, make sure you review that notice. There are supposed to be guidelines on on safety measures at the USCIS offices. They're going to limit how early you can arrive, how many people can accompany you. And of course, there will probably be guidelines about temperature, face masks or face coverings, depending on the state or local guidelines. So make sure you review those.
Kishore, you want to go for Q&A?
Yeah, sure, Rahul. Again, I am unmuting all the participants, and I'll mute again. Anybody who ever want to ask a question, you can unmute yourself and you can ask questions. Yeah, now you should be able to unmute, and yeah, Reshma, you can ask your question.
Hi, can you hear me?
Yes, we can hear you, Reshma.
Yes, so my first question is, did you say August 13th is when USCIS furlough starts?
I believe actually that it's August 3rd. I think Rahul, you're muted again, but yeah, I believe the target date right now is August 3rd for when the furlough is expected to occur if USCIS doesn't reach an agreement with Congress before then. I would say based on news reports, it's likely that Congress will provide the additional funding that USCIS is asking for before then, but as we've seen with other kind of budget standoffs with Congress, a lot of times they leave it until the very last week or last day before they reach an agreement. But I think they most likely will, but yeah, to be safe, like Rahul said, if you can file before August 3rd, that would be prudent.
Sorry for the date confusion. It's not 13th, it's 3rd. Sorry.
Okay. So my application has to go to USCIS?
No, it has to be, there is nothing, no rule that if he goes before they're going to adjudicate properly. The better way is that to get it premium processing if you're eligible for it, ma'am, okay?
Right.
The better way is to file as soon as possible. There is nothing that if you file the application right now, and if the furlough happens, you will be affected for it.
If the university is changing something else, so they have to get the F1 again.
Any more questions, guys?
Hi, Rahul. Good evening. This is Satya here. I have a question. Basically, my extension was filed in the month of February, the H1 extension, and then it got into RFE, and then my attorney filed the response on July 1st. I mean, at least in the USCIS website, it shows that they received the applications on July 1st. So having the, it was not in premium processing. I don't know whether you want to suggest us the premium processing.
Yes.
Okay.
Don't even ask the question. Premium processing, go for it.
Okay. Just one question. Like in case if attorney says, no, let's wait and everything, it's our employer attorney. In case, that happens, when the furlough happens, what happens to the 240 days rule?
That will be still there. The 240 days still will be there. So if it crosses 240 days rule, you are gone. I don't see any reason right now your lawyer will say no for the premium processing.
I get it. Okay. Thank you. Thanks for the information.
Hi, my question is to Rebecca. My name is Saurabh, and this is regarding the ICE directive that came, I think, last night or day before that on for F1 students. So is there any impact on the CPT? Like I am left with only one subject and I can take CPT for that.
Are you going to the day one CPT universities?
No, this is not day one CPT. This is like internship. You
Which
can take the
university?
internship.
Which university you are in?
I'm in University of Central Missouri.
Okay.
So they are already, I'm done with the 9 subjects. I'm left with 1 subject for which I can take the internship. So it is CPT. So is there any directive that because of conditions right now, most of the CPT, even if I get internship, it will be work from home kind of environment? So is there any impact on that?
Not from what we've seen. So as long as your CPT is, according to the rules of, normal, that are under the normal conditions, that should be fine. Yeah, the work from home situation for CPT or OPT, even technically, I think OPT or CPT without a pandemic remote work would be technically okay, as long as you can still show that there is the supervision occurring and the training going on. So as long as those conditions are still there, I don't see that work from home would invalidate your CPT in any way. The recent announcement is more for classes being online or in person.
Sure. Thanks, Rebecca. Thanks, Rahul.
Thank you, sir.
Hi.
Hello.
Hi, Rebecca. Hi, Rebecca. This is Funny here. My question is like I have filed an I-539 change of status for my wife from H1 to H4, and I think like there is no premium processing for that one. So unless the application has been sent to USS, I think there should be no problem for her to stay in the US.
Right, that's correct. As long as it was filed while her I-94 was still valid, it will likely be pending for a long time, like potentially a year, depending on how long it takes the biometrics to get caught up. But yeah, as long as it was filed on time before her I-94 expired, she is in a period of authorized stay, even after the I-94 end date, while the application remains pending.
When is your H1B expiring though?
I have until 2022 December.
Oh, she can stay legally if the H4 is not adjudicated until 2022 December.
Okay. Thank you, Rahul. Thank you, Rebecca.
Hi, this is Sam. My status is like my 6 years H1B is ending on October 13th, and yesterday they filed the perm processing, and we got the perm's application number. So my employer, they sent an email like saying, since we don't have much time and due to this pandemic and stuff, like they're asking me to wait till September and like stop working from October 1st, and asking me to do a status change to B2 and wait until it is approved. So today I saw the news about the USCIS employee situation, so I'm little worried, and I want to know what is the best option, whether to convert to B2 or just go back and come back when it is approved. Like,
I would strongly recommend that you go back and come back though. The problem here is that to expect the B2 to be approved, okay? To expect the B2 to be approved and then get back to H1B is not practical at all. B2 take 8 months. You can only request 6 months of the B2 extension. The other thing is that they're telling you to stop working from October because your H1B is not there. But if you're in India, there are no rules for you. Practically, you can even work. You can continue working.
okay.
So you'll be much better off if you leave the country in October. You wait until the I-140 is approved. And once the I-140 is approved, you can file the H1B, hopefully starting anytime after January of 2021, and come back into the United States. By sitting here, you cannot work. You're just sitting here. I do not advise you convert into B2. I advise you to leave the country.
Yeah, thanks for the input. Thanks, that helps.
Hi,
Hi.
Rahul, this is Uday. I have a question. I applied for my H1B, H4 and H4 EAD at the same time, and I later converted the H1B to premium process. My H1B is approved for 3 years, like until 2023 end. But my wife is working on H4 EAD. I'm little concerned now because I have not got any update on the fingerprinting. So what is your best guess of how soon the H4 can be approved?
You want the best guess or you want the normal guess? You want it is going to take anywhere between 8 months to 18 months. And there is nothing we can do right now. We used to have a court litigation process. It is on pause because of certain technical issues right now, but there is nothing anybody can do right now.
So do you foresee the situation go even worse?
Absolutely, yes. This administration wants to get rid of the things. He couldn't get rid of the things, so he's delaying everything out.
If she has an option, if she has an option to move to H1B, is it a better? Do you advise?
Does she?
Yeah, she already had a H1B before,
Got the point.
and then she converted back.
And when is her current H4 expiring?
October this year.
I would strongly recommend she convert into H4 to H1B. Let the H4 extension and EAD extension be there. Don't worry about it. Don't pull that off. File the H1B, okay? And if once the H1B is approved from October onwards, she can start working on H1B. Even before October also, she can get the H1B approval. And when the H4 gets approved, she will convert automatically to H4. So I would recommend strongly to file a H1B for her, Uday.
All right. Thank you so much, Rahul.
Thank you.
Hello. Hello. Hi. Thanks, Rahul and Rebecca, for doing this one. I have a question related to H1B. Because I'm recently laid off and I know I have the 60 days to get the job. But in this situation, I'm thinking it's very tough to get. But my question is, like hello, can you hear me?
Yeah, keep going.
Yeah, so in that case, my plan is like, if I or my wife want to do the MS and go for the F1, is it and any of one can be on the F2. Is it a good idea to do that one at this case, or you recommend after 60 days go back to the India?
One thing you need to understand is that if you want to change the F1 student visa status, the same rule what Rebecca said about H4 is not applicable for F1 visa. In the H4, what she said is that if you file before the I-94 expires, she can stay in the country for a long period of time until the case is adjudicated. When it comes to the F1 visa, you have to maintain the legal status until your F1 is approved. F1 by itself is taking anywhere between 10 months to 24 months. So your H1B is out within 60 days. You still have to maintain the status. So then you have to file a B2 application. The B2 is only for 6 months. And then you have to file one more B2 application, and then you have to file one more B2 application. With all this stress though, under the current circumstances, the best thing is that if you don't get a H1B opportunity, I would strongly recommend that you leave the country and come back when the things get better. Because if you do all this B2s, F1, and then if you're going to have a problem getting the H1B, you go outside the country, the counselor is going to look very down on you.
Hi Rahul, this is it. I have a tricky question. Like I have been applied for amendment in 2019 and it is more than 350 days now, and I have an extension on coming October. So can I go with an extension in this case, like for the amendment is in progress and because of this?
When is your I-94 expiring?
In October.
I am thinking, Rebecca, that he should do a premium processing for the amendment though, and then go for the extension. What do you say? Or just go for the...
Is there an application pending already right now?
Right, it's been pending for 350 days for the amendment. And I would strongly recommend that you do premium processing, because if by any chance you get the denial of the amendment though, you can file one more amendment plus extension before October.
Okay, can't we go for direct extension in this case?
Rebecca, I think so he should still get the amendment premium though. What do you say?
Yeah, I would recommend if possible to upgrade the amendment to premium first and get the
You may,
decision on
yeah,
that?
yeah, you may face some problems if you directly go for this one and that amendment is still pending. They may say that, okay, we want that amendment to be adjudicated.
Mhm.
For
Yeah, I
all
think that's
reasons, since your I-94 is not expired though, go for the amendment premium processing, sir.
Okay.
Hi,
Okay.
Rahul. Hello. This is Raghu. I have a question. My cousin, he's finishing up his OPT in August, and then he already applied for H1, and his H1 is picked up. And a question here is like, I mean, he didn't get the approval yet. The question here is that with the new law or like new rules, something like the OPT students or like the students who are going to the college should leave the country, and then
Well,
like,
that's not applicable for the OPT students though. What
Okay.
Rebecca was pointing out is those people who are now supposed to attend the classes. If they don't attend the live classes, there are some restrictions on it. But for this guy where the OPT is there and he filed a H1B, that restriction is not applicable to him at this point of time.
But the thing here is his OPT is getting like it's coming to an end in August, and his H1 will only start in October, right? So in this period, he also enrolled in a new college, thinking that if something happens, he can go to the college. But can he work?
He is eligible for a cap gap. If his H1B is selected in the lottery, if his STEM extension is expiring in August though, he is allowed to work until October. I don't see a reason why he has to enroll in a classes. I would rather spend the premium processing and get the H1B approved. If by any chance H1B gets denied, then I will consider going to the college.
So the gap period, he can still work between
That is called cap gap, yes. But I would recommend that he should not even go to that extent at all. Do premium processing.
Okay, sure. Thank you.
Hi, Rahul. This is Pawan. No, wait, Pawan. I want to re-emphasize the people that instead of doing all these things, going to the cap gap, trying to go to the university and all those things, just spend the $1,440 or whatever that money it is to get the premium processing approved. That is so simple, guys. Otherwise, you will get into trouble. He will get a decision in July. And if he gets approval, his cap gap is there. He doesn't have to join the college. And if by any chance it gets denied, then he can then consider the other options, what he's looking into.
Okay, sure. Thank you.
Hey, Rahul, this is Umesh. I have a question related to EAD processing based on the I-485. I know that there is a 6 months automatic extension, but what happens if the 6 months, if the EAD doesn't get processed before 6 months expiry date?
You can still stay in the country, but you cannot work.
Okay.
Hi Rahul, this is Pawan.
Just please note that this particular question I answered is only for the adjustment of status EAD, not for H4 EAD. Those are two different EADs. So don't take the same example, guys.
Hi Rahul, this is Pawan. I have a question on my H1 extension. So my I-94 was expired back in on May 11th. And after that, I have recapture time until June 30th, for which I have filed both H1 and H4 extension applications. So
June
now
30th of which year?
2020 actually. So that is also, which is over. So now I have converted into B2. I'm just waiting for getting a flight and going back to India. So my employer is saying after I go back to India, he's going to withdraw both H1 and H4 petitions. Along with, actually, they helped me file B2 also. So they are saying they will withdraw B2 petitions also, because I wouldn't be able to give biometrics or anything because I'm out of USA. I have the receipt notices of H1 and H4 already with me. So will this cause any problems or will that time be considered as illegal stay or out of status?
No, that's fine. They have withdrawn it after you left the country, not when you're in the country. So I don't see any problem in it.
So tomorrow, my I-140 is going on now. Tomorrow, if I go with the H1 extensions or H4 extensions, will this time period cause any problems?
No, sir. It will not cause any problems, sir.
So I can just show the receipt notices for both.
That
H1
is absolutely fine.
And
you
for
show the
B2
receipt
period
notices.
also?
That is right, sir.
Hi Rahul, this is Raj.
I have a question related to perm filing. So my prevailing wage determination was completed in January, mid-January. And since then, my attorney always says your recruitment is still going on. Your second part of recruitment is still going on because of COVID. So I want to know how much is the total duration for which this recruitment thing keeps going on, because it's already close to 6 months.
Yeah, Rebecca, 6 months is an appropriate time, or I think it is. What do you say?
It could be, depending on the situation.
Prevailing wage. See, they club all the things into one thing called recruitment, but there are a lot of things involved in it. There is something called prevailing wage. There is something called advertisement. There is something called recruitment. So normally people use the word recruitment to club all these three things. Is 6 months a reasonable time? Yes, absolutely, it's a reasonable time. Is 8 months a reasonable time? Yes, it is a reasonable time. Is 12 months a reasonable? I don't think so. Is 1 month reasonable? No. All these things cannot be done in 1 month. Absolutely not.
But Rahul, I heard that when the first advertisement was posted, from that date, within 6 months or 180 days, you should do the perm filing. Otherwise, the advertisement goes.
You are right. You're right. But we don't know when they did the advertisement.
Right. Yeah, they are not telling the complete story.
Right.
Saying
So there is called. That's the reason why they club all the words into one. Prevailing wage. Most of the employers will wait until the prevailing wage comes in before they advertise. They don't just advertise and get the prevailing wage. There are different methods each employer processes. But 6 months is definitely a reasonable time. 8 months is reasonable, but 12 months may not be reasonable. That's my opinion.
Okay.
Hi Rahul, this is Venkat. I have a question. I'm currently on H4 and I have enrolled in one of the university, and I'm currently in my second semester. I thought of going back to India and getting converted to F1 because the COVID, I'm not able to do that. So what are my options right now at this point of time?
What visa you are in right now?
Currently on H4.
The assumption that you go to the consulate and they give you the F1 visa with flowers to you is a dream though. A lot of H4s get their F1s rejected. Do you know that?
I'm not aware of that.
Yeah, a lot of people. The reason is that for H4 visa, you don't have to show that you're going to go back to your home country once your H4 is done. Okay? You can say that I'm going to get a green card, I'm going to stay there. There is nothing anybody can do. But in the F1 visa, you have to show that you're going to go back to your home country once your education is complete. Especially you were here on H4, your wife is here on H1B, she has a house or an apartment staying here. They don't think that you're going to come back after the F1 has been after you complete your F1. So there are a lot of risks in going outside the country though. If you want, you may consider changing the status from H4 to F1 here in the United States.
Okay. And I heard like it's going to take more than 10 to 12 minutes.
Absolutely.
If that is the case, I'm going to lose the OPT and all that stuff, right?
You can delay your graduation if you want to. On the H4 visa, you don't have to attend full courses. Once the F1 is granted, you can attend the full courses if you want to.
Okay.
Hi Rahul, this is Shiva here. Can you hear me, Rahul?
Yes, Shiva.
Yeah. So I have a question on amendment plus extension. So I actually got promoted recently to engineering manager. So I heard a rumor that managers do not get H1 easily. The question is that true? And then also I'm also actually moving from another state from California to Texas. I'll be working remotely. This is my 5th year in the same company, and this is my 2nd extension. And the third, actually it's a 3rd extension in the same company. And they're actually trying to do amendment plus extension together, even though I still have another year of quota, another year of visa. So
that's the point. Yeah. What is your opinion, Rebecca, on engineering manager though? You do a lot more H1Bs than I do.
Yeah, as long as the degree field is in an engineering field, I don't think there would be a problem. I assume you got promoted to an engineering manager position from an engineering position, which means your degree is likely in engineering, correct?
Yeah, that's correct.
Yeah.
It's a bachelor.
That should be fine. It's more problematic if the background is a business degree. Applying for a manager position for H-1B, that can be difficult. But if it's a technical background and you're being promoted from an engineer to a manager, I don't see any problem with that for a specialty occupation. They can classify you as an engineer with a higher wage level on the LCA, or there's also an occupation classification for engineering managers. So depending on your job duties, the attorney would decide which of those SOC codes to use on the LCA. So yeah, I don't see any problem with that for a specialty occupation for the H-1B.
And then also you have 1 year of H-1B still left. I like your lawyer's idea to file for amendment plus extension. Then they're doing all the paperwork. I might do an extension too for you. That's a very good idea. If by any chance, what Rebecca said doesn't happen also, you'll get a second life.
Yeah.
You can file one more application.
Right. Yeah. That's right.
Hi, Rahul.
And also, I'm actually moving to another state and I'll be working remotely from home.
That
Have you
doesn't make
seen
any difference.
That doesn't make any difference,
No.
right? So they cannot question your not working.
They can
from
always
office.
question, but I don't see that any percentage of denials high because you're working from home.
Okay, thank you.
Hey Rahul, so Rahul, my H1B got denied a week back. Hello.
Keep listening.
Yeah,
Keep
so
going.
my H1B got denied a week back. I joined this company on receipt, but my previous employer's H1B is still not revoked. It is up in approved status. And also the I-94, which is listed on the I-797 form, is valid till May 10th next year. So now I have two questions. Can I stay in US legally? And if yes, then till how long? And the second question is, are you going
to work for the previous company? Or are you going to just sit down and stay here?
No, I can't join back the previous company. So what I'm thinking is,
you said you can or you cannot?
I want to, but currently they're not recruiting any H1Bs.
So you're not going to join that company. Okay.
Right. Now, with the I-94, what I have till next year, May 10th, can I ask a new employer, any other employer, if I find a project, to file the petition I-129, or I have to
when did your company's H1B transfer got denied?
A week, 25th of June.
We do consider, we have made successfully this argument, but Rebecca is going to clarify it more clearly though. Rebecca, is the 60-day rule not applicable for him? Because his I-94 with company A is expiring in May of 2021. His transfer got denied right now on June 20th.
Right. I think different attorneys have different opinions on whether the 60-day grace period applies here. In my opinion, it does not, because I think the 60-day grace period rule is if you lost your job or left the job with company A that has the approval for you valid until next year. I think that's the scenario that the 60-day grace period was.
But can he try? Can he try with company C right now in premium processing with 60-day rule?
Can try. If you are going to try, I would definitely file in premium processing and be aware that
I have to tell that there are some cases that got approved, and as Rebecca was pointing out, that each lawyer has different opinion on this one. Yeah, in our office also we have different opinion on that. You may try though, but if you try though, we strictly recommend that you stick with the premium processing.
And I mean, should I leave the country? Because some people tell me that my stay is illegal. I have to.
We have difference of opinion in this one. Rebecca says differently. I'm saying differently here.
Okay.
So it's up
the
to
reason
you.
the reason we're recommending premium is so that you can find out as soon as possible if it's unsuccessful, so that if it is unsuccessful, then you can leave without accruing more unlawful presence.
Okay. Got it. Thank you.
Yeah, Rahul, Karthik here. Can you hear me?
Good, Karthik.
Hey, Rahul, thanks. I'm currently in my H1, and my H1 is expiring on January 31st of 2021. And my wife is on H4, and she has a EAD, and she is also working, which is also expiring around the same time, January 31st of 2021. My employer is working on filing the extension for me, and they are going to file it in premium. And they said they'll be filing it as soon as I hit the 180 days mark.
Of course.
So considering the current furlough and things like that, I'm not sure if my wife's EAD can be approved before January 31st of 2021. Mm-hmm. So wanted to know what are the options do I have for her to continue working?
Was she ever on H1B?
No, she was never on H1B.
Yeah, she can go to the congressman, request it, which they're going to deny it. She can request an expedited processing, which they're going to deny it. But there is nothing else that I and Rebecca can offer you right now.
Okay, thanks.
Hello.
Sorry about
Rahul, Rahul, this is about earlier. I asked that question about OPT. The thing is, actually, he moved to CPT.
It's better that he speak though, rather than you. Okay.
No. He's saying.
I know. No, let him speak. Let him speak, sir. Let him speak, sir.
He's on CPT right now.
Sir.
But he's working right now. So what should
I have a question.
Yeah. He was on OPT, now he's on CPT. Let him come directly and speak, cousin. Let him speak, okay? Because let's use the time for the people who are here rather than the people who are not there.
Hi, Rahul. I have a question. So basically, I came to the US in 2015, and my F1 visa has expired, and my OPT has been expired as well. So I joined second master's, and I also applied for my F1 on my last attempt. So I have two questions. Is there any complication since my F1 has expired? Other than
when you say your F1 has expired, you mean to say your visa has expired?
Visa has expired. That's right. Yeah.
Visa expiration has no meaning as long as you maintain the legal status. But if you have joined one of these day one CPT universities, we do not recommend that at all. But if you joined a proper university for second master's, we don't have a problem with it.
Okay, understood. So my second question is, if I applied for my H1 on my last attempt, which was in March this year, and I didn't get any, I didn't get picked for the lottery that was taken in April. So my question is there still any chance?
We're getting a lot of disturbance on your phone though.
Okay. Sorry, give me 1 second. Any better now?
Hey Rahul, in the meantime, Harshita here.
Hello.
I have a question. So can any employer revoke one's H1 without acknowledging the employee?
They are supposed to inform the employee in email at least. That is what we strongly recommend the employers. But if they don't inform, Rebecca, what would be the consequences be if they don't inform the employee?
Yeah, it's for the company. If they never give notice to the employee, they could be liable for back wages because it is kind of a 3-step process when an H-1B employer terminates someone before the I-797 approval notice expires. They're supposed to give notice to the employee, withdraw the petition, and notify you as CIS. So
okay. How much upfront should an employee should inform their employer?
They don't have to give any upfront. Just they can give 1 hour notice. That's fine.
Oh, okay. Thank you.
Hi, Rahul.
Hi.
I have a question. I'm on H1B, and my current employment is over. Since they don't have projects. So, and I have an offer from another consultant, but they are asking that I have to join on the receipt since they don't have a client letter before I join them. So I am at risk of joining them on receipt and maybe a rejection later on. So is there any other option do I have?
No, but you have to either pick leaving the country because you don't have a job right now, or joining the company on the receipt notice. I would join the company on a receipt notice. I don't see anything illegal in it.
And so should I file a premium or should I just file a normal one since I don't have another offer right now?
There is no need for premium processing in this one. There is no need because you said that the end client documentation is not there. Maybe if you go join and you spend more time, you get more connections there. You may be able to get the things better at that point of time. So I don't see a reason to do premium processing right now.
Okay, yeah. Thanks, Rahul.
Hello, this is Sai. I have a question. Basically, my I-94 got expired, and my I'm close to my 180 days being after my I-94 expire. So, is there a way that I can have an extension of 1 month or 2 months to stay in this country legally?
No, sir, that is very risky though. I want you to leave the country. There are special flights that are there right now. No matter what you do though, once you cross the 180 days, there is a good chance you'll be hit with a 3-year bar. Under all circumstances, I don't want you to take any risk and I want you to leave the country though.
Thank you.
Hey, Rahul, I have a question.
Rahul, can you please unmute yourself? Yeah, I know we have a lot more questions, but there are a few questions on the chat window, Rahul. Let me ask a few questions from the chat window. I have been told that I'm going to be promoted, which will be effective in next 2 weeks. Am I supposed to file an amendment for this title change?
If it's a significant change in the job duties, then they are supposed to file an amendment. When there is a promotion, does it mean that they're only giving $1,000 extra per year? Or is there a significant change in the job duties? If there is a small, minute change, they don't need to file an amendment. But if it's a major changes, they need to. Who will determine? It's the employer and the employee and the lawyer of the company that will determine.
I arrived here on a B2 and filed for my B2 extension and F1 at a university which is offering a hybrid program. I want to ask what are the approval rates or chances for those filing from B2 to F1 given the state of pandemic?
Well, one thing is that these hybrid universities before the pandemic though, I don't think so Rebecca and I have ever approved any of those universities though. Because of the pandemic, we understand the hybrid system. We support the hybrid system. Of course, we support the online system right now. But there are some universities like Cumberland, Campbellsville, and Harrisburg. They are not legal universities, Kishore, at all.
Okay.
They don't come under this ICE preview, what they put in the notice. What do you say, Rebecca, of these day one CPT universities? They never follow the rules anyway.
Yeah, those programs are not technically affected by the most recent guidance because they have never really been recognized as valid maintenance of status anyway by USCIS.
COS from H4 to F1 is currently pending with USCIS. Have any effect with this new SVEP guidelines? Can they stay in US or they have to depart US?
Depends on if the H4 expiration is still valid though. If their H4 is valid until 2022, I don't see any problem. They don't have to leave the country though. Even if the F1 gets rejected, it won't have a negative impact on the H4. But if the H4 is expiring, they should apply for the extension. That's number one. But I will ask the tough question to Rebecca. For the applications that are pending right now, what should they do? What if the university says we're going to conduct online class, like the Harvard University?
I don't know. There really isn't any guidance for pending F1 applications. I mean, what the guidance suggested was that if students who are here in the US in F1 status already attending schools, and those schools decide to do an online only format for this fall, they're supposed to transfer, either leave the country or transfer to a school that has live instruction. I don't know that you can do that when the F1 change of status application is pending.
Yeah, there is a good chance that if they are only online courses and they as Rebecca was specifying, by July 15th, they have to specify to the SBBP portal either they are going online only, live classes only, or a hybrid system though. If they are online classes though, I am expecting that their F1 will be rejected, Kishore.
Yeah, okay.
Yeah, or that they would get an RFE on the pending I-539 asking for the I-20 that certifies that the school is not online only, which if they're not able to provide, then yeah, the F1 would be denied. Yeah, it's a very difficult position that this guidance is putting a lot of students and schools in. I don't know if we mentioned earlier, but there has been a lawsuit that's been filed by Harvard and MIT already today against implementation of the guidance. So hopefully the court will issue possibly a restraining order, a temporary restraining order from implementing the guidance until it can be more thoroughly reviewed by the courts.
Last question for today. My H1B extension 240-day completed in April 2020. So moved to B2, awaiting for the biometrics. I have resigned from my previous employer and they have withdrawn my petition. What is best for me? Look for a new employment or wait on B2?
What was this guy doing? Was he smoking weed? Why did not he do premium processing? One, answer the question, he should leave. He resigned the job, he applied for B2, now he should leave. There's nothing there for him to stay because he cannot be converted back into H1B. Okay. Rebecca, you have any suggestions for the people they don't do there is a conception that if you do premium processing, you get the H1B denial. Is that true?
No, yeah, there is this kind of long-standing rumor that filing in premium processing increases your chances of getting an RFE, which based on our observation, we have filed thousands of H1 applications each year even. And so we have, we think, a pretty good statistics and observation of the chances of getting an RFE, when an RFE is going to come, and whether filing in premium, because we file in premium and regular all the time. In our observation, filing in premium processing does not increase your chances of getting an RFE. The perception may be there because if the case is one that's going to get an RFE anyway, the RFE will arrive faster because USCIS has to act within 15 days. And so it may seem like an RFE arrives, but if an RFE is issued for a premium processing case, that RFE most likely would have been issued also for the case if it was in regular processing, but it would be 8 to 10 months before you receive that RFE.
Thank you once again, Rahul and Rebecca. I know it's 5 minutes more than what we planned for. And I also posted the group link. So in case if you have, we have Rahul, Rebecca, Emily, they do daily sessions for our group members. So you can be part of that group where we post about the daily immigration calls, and also Tuesdays we have a Facebook call which Rahul, Emily, and Rebecca does it on Facebook Live. So you can join the group, you can attend those calls. Thanks Rahul and Rebecca for taking time.
Thank you, Rebecca. Thank you for Kishore for giving the opportunity.
Thank you for having us.
Thank you. Thank you everyone. Stay safe. Have a nice evening.
Yeah.